All right, good afternoon, everyone, and thank you for joining me at this, which is going to be our last constitutional law lecture before the examination, unless, of course, there are any burning issues you want us to discuss at a later stage. But so what I'm going to do today is to provide you with the scope. And I've thought about it. I don't know how to give you this scope, but I've given it a little bit of thought. And let me put it this way. There are 6 separate questions to be answered. And I have therefore tried to cover all of the 8 chapters within those 6 questions. So there isn't really anything you can leave out. But remember that this is an open book exam. So if you are familiar with the information, know where to find the information, then you will know exactly how to obtain the best possible information that you believe is relevant for the specific question. So having said that, as far as the scope is concerned, you have probably gathered from the way I've been communicating constitutional law to you is it's fundamentally based on important concepts or doctrines or theories or philosophies. So invariably the questions will be stated in a way that will say, maybe it'll have a quote, and then it will say what theory or concept or doctrine is being discussed or being referred to here. And then you need to identify the relevant theory, concept, doctrine, philosophy, whatever it may be, and be able to clearly explain your understanding of that theory or concept. And remember that in law, it is absolutely imperative that you use case law at all times to substantiate what you mean. So case law and particular provisions of the Constitution, all of which you have available to you during the exam. So the essence is that none of the questions are going to are designed to mislead you or to ask more than you would conceivably understand. Each of the questions is simply based on what we've already discussed in this module, and it would then expect you to be able to answer the question using the appropriate style of referencing, like was used in the feedback to assignment 2, which I've now also put onto the first semester module site for the benefit of those students, because you do have more than enough time. And I can't say this enough, because you might not be aware because you're relatively new into your LLB degrees, but in the pre-COVID days, Every single exam at UNISA in the College of Law was 2 hours. And it was a 2-hour exam for 100 marks that was closed book, and students still managed to complete the exam, obtain distinctions. So you really do have an advantage now. Your numerous advantages. Let me put it this way. The advantages of having access to your material so that if you can't remember a case name, but you have an idea about where it fits in and which chapter you read it, you can find it. You know that in tutorial letter 102, I have included new, relevant, interesting cases where I've actually spent time trying to delete the paragraphs that are not absolutely essential so that it makes your reading of it quicker. And we've included a commentary at the end of those cases to try and indicate to you what the relevance of that case is. So you are very much in the fortunate position that you have access to this material while you are writing, and you have more than 2 hours available to you in addition to what students used to have. Because as you're aware, if your exam starts at 8 in the morning, you are allowed to start accessing the exam paper from 7:45. And so from 7:45 until 8, that's 15 minutes, in which time you could read through the questions. And I don't waste a lot of time with long scenarios. I've tried to keep all the questions short and to the point. All of the questions are not even a full page worth, with big spacing in between. So you have ample time, meaning, and I can't say this enough, do not fall into the trap of thinking that you can simply copy and paste whole paragraphs, either out of the tutorial letter 102 or out of the textbook or any other source, and think that you will get away with it. I'm going to be very clear with you now. The Invigilator app that you have to use is an excellent app for lecturers because it shows us exactly which papers students' answers are too similar, and it therefore shows us which answers are simply copied and pasted out of the material. And I'm right now sitting with 300 students from international law that I've had to refer for disciplinary hearings because of the extent of cheating that was found through the Invigilator app. And that can bring an end to your whole academic career and your future. So please, the whole point of this exam, and I do try to say this in the questions, is explain it persuasively, using your own words, or where you cannot use your own words, you actually place those words in inverted commas, have a reference saying page 72 of Pierre de Vos and Warren Friedman Constitutional Law in Context, so that you don't run into any possibility of being expelled from the university. Remember, the Invigilator app also listens for the whole 4 hours that you are writing the exam. So do not find yourself in the situation that other students have done in other modules, where the lecturers caught the students actually saying to someone on the phone, Thank you for the answer paper. I will send the money now. Do not do that. I know it sounds as though it's something you would never do, but there are students who buy answers and then they all submit that identical answer. In fact, 83 of them in international law did it, and they, for some reason, thought that they would never be caught. And even these very dubious sources like Course Hero and Give Me Notes, that material is in the public domain. So if you rely on it word for word, I will know because the Invigilator app will say this information comes from that source. And then your answer, in fact, the Invigilator app comes up as an automatic fail. And then I have to look at it and say, okay, is it really information that you've copied from someone else? Or can I see that you've referenced the work and you've tried to use your own words, and then I can pass you? But the default position, if you've copied other people or just bought an exam paper, yes, that's the one thing you certainly shouldn't do because you're wasting your money and prejudicing your career. If you don't submit that kind of a document and think you'll get away with it. So the questions, it's 6 very simple questions where I ask things like compare and contrast different institutions. Now that's not difficult to do. All of the information is available to you by the provisions in the Constitution, the material in the textbook. But if you don't have the textbook, we will allow you to quote from tutorial letter 102, as long as you at least say on page 63 of tutorial letter 102, it is explained that the institution of the judiciary is, that kind of thing. And then you explain with reference to appropriate case law. So I really don't know how to give you any better scope, because there's nothing that I can say you can definitely leave out, except for that very detailed history of South Africa that you need to be aware of so that you understand that we have this transformative constitution. But I'm never going to ask you what happened in 1652 or 1910, because what we are concerned with constitutional law is, what does the Constitution of 1996 say? How has it been interpreted by the courts and by scholars? So that's why the textbook is written in a way that will explain the information, and there might be a part that will say, think about this issue for a while, because it's something that's slightly out of the narrow confines of the study material, but is somehow relevant and is there to try and enable you to think more critically, because that is what a law degree is designed to do. It is designed, and that's why I'm actually quite satisfied with an open book exam. In law, the skill is more about knowing where to find the answers than simply knowing the answers in your head, because there are too many cases, too many provisions of the Constitution that you can't possibly know off by heart. So the skill that is being examined in this for our exam is, can you identify that concept or theory, which is something that we will inevitably have discussed in detail in the lectures? And so you should instinctively remember, okay, yes, I know about the separation of powers doctrine, or the principle of constitutional supremacy, or the concept of judicial independence. So they're all familiar to you, and every single thing is in the textbook or in the material or has been discussed in these lectures and is in the Constitution itself, and is invariably then referred to in numerous cases. And that's where your ability to earn a distinction, for example, is defined. Because sometimes I am looking for an answer that shows a higher level of thought. For example, you might look at the EFF1 case and recognize something peculiar about that case that is essential for explaining constitutional democracy. Whereas I have been focusing in that case, for example, on its importance in the context of the legislature, the National Assembly, holding the executive to account, consequent upon a report by the Public Protector's Office, which recommended that the National Assembly take remedial action so that the president pays back an amount of money by which he was enriched. But it is a case that deals also with constitutional democracy. Because if we know that constitutional democracy as a theory means that the judiciary is allowed and empowered by the Constitution itself to feel free to declare any law or conduct unconstitutional, because the Constitution tells us that the judiciary must do that. But then you must understand that in a constitutional democracy, like the essence of the Economic Freedom Fighters 2 case has pronounced to us, that the judiciary still respects the separation of powers doctrine by only going as far as declaring something as invalid and unconstitutional, and then referring the matter back to the appropriate branch of the state, saying to the legislature, you now need to draw up rules. So that shows us that in a constitutional democracy, the separation of powers that we have in South Africa is a decolonized form, because we haven't accepted that rigid style and form that's used in Europe, but we've created for ourselves a method by which the separation of powers doctrine functions to ensure that the Constitution is given meaningful effect. And cases like the first case that's in the part 6 of tutorial letter 102 about AfriForum against the Tshwane municipality. Oh, that case has got so many interesting dimensions to it that you could rely on. You could use that case to explain, for example, the principle of subsidiarity, because that case illustrates unambiguously that if our multi-sphere system of constitutional democracy in South Africa means that the most power must be at the sphere where it will impact the people the most, then surely it's the municipality that is recognizing its duty to pay homage to those people who fought in the liberation struggle to end apartheid in South Africa, and that therefore to enable the majority of the people in this municipality, so in Tshwane municipality, but we know that it also applies in other municipalities. But the municipality then was simply saying, we are empowered to change street names so that the people driving on these streets recognize their own heroes. And you can also use that same case, the AfriForum versus Tshwane Metropolitan Municipality case, to show that the judiciary can declare law or conduct constitutional, even though an entity like AfriForum feel that it is denying the rights of the white minority in the same municipality. But look at how the court reasoned. The court said, we need to recognize that the time is now to move forward and to no longer highlight or accentuate only those few white historical figures. So AfriForum were told, you pretty much just have to suck it up, that in this constitutional democracy that South Africa is, where our aim is to transform society, the municipality has actually taken appropriate steps in decolonizing society and changing the municipality into one that is more welcoming to the majority of people in the municipality. So the point I'm making here is it's your ability to use relevant parts of cases convincingly to substantiate your point, because there isn't ever only one case that is the correct case. It really does come down to how well you can explain the relevance of that case and try to find wording from that case where the court is explaining the concept or the principle well. So I know that you're probably still thinking that you don't have enough of a scope, since you are all very desperate to know the scope. But there is nothing more I can say except if you acquaint yourself with that diagram on page 6, and you see those words that are prominent, like the rule of law, constitutionalism, separation of powers, the public protector, the independent electoral commission, the national prosecuting authority. All of those are fundamental to how our Constitution was envisaged as a document that would be used to ensure that the government that is elected every 5 years adopts appropriate policies, and they then introduce relevant laws into the legislature. The legislature goes about the process of formulating that policy into a green paper. They send it out and say to the public, give us feedback. It's reformulated into a white paper. And again, the legislature is supposed to say, we are calling for public participation in terms of Section 59 of the Constitution. And so the people must be involved in formulating this bill, which is then voted upon by the National Assembly. It's then transferred to the National Council of Provinces for the National Council of Provinces to vote on. It then goes through the process of being referred to the President as head of state to sign this bill into law, but he's allowed to refer it back to the legislature if he has reservations, and he's allowed in our constitutional democracy to refer the bill to the Constitutional Court if he's not entirely convinced that all of the provisions are acceptable. So that diagram has a lot going on, but it's everything you need to know in one. And then it is the elaboration of that diagram, which is contained in the rest of tutorial letter 102, followed by those significant cases that really have transformed some of our previous beliefs about how the Constitution works. And so one of the most important in that regard is the fact that up until the EFF1 case, no one actually knew with any certainty whether the decisions of the public protector are binding and enforceable or not. And fortunately, because the EFF took that case to court, saying the public protector has made a recommendation and the National Assembly is doing everything in its power to absolve the president of any liability. And that's why the EFF were forced to eventually have to resort to going to court to seek clarity on the matter, because they, as a minority political party, were feeling that our dominant party democracy in South Africa was actually denying minority political parties of any power, because the ANC would simply push the EFF's views aside and try their best to ignore the issue and try to protect Jacob Zuma at all costs. So you see how important that case is for our understanding, in that if you, for example, have the first edition of the prescribed textbook, the first edition was published in 2014. And so for the most part, the content in that book is perfectly acceptable. But there is a part in the first edition that tells us, but the decisions of the public protector are not binding. And if you then in the exam write that, for example, I will realize that you have not bothered to read tutorial letter 102, and most importantly, you haven't bothered to read the EFF1 case and recognized that that EFF1 case has the single dimension of dealing with the public protector and the powers of the Office of the Public Protector, but has also got an entirely different dimension to it, hence the EFF2 case, which concerns the fact that we can't possibly have a constitution that says in section 89 that if the president is guilty of serious misconduct, is guilty of a violation of the Constitution, or is guilty of a violation of any other law, that the president must be impeached. Yet we have this perfect provision that we could never implement, precisely because the dominant party in the National Assembly were obstructive, but more deeply, the problem was that there were not clear rules regulating precisely when and how a president should be impeached. So those two cases really have fundamentally shifted our understanding of constitutional law, because we now know that the days of impunity of a president, and even if we think about judges and now the public protector, who are also liable to be impeached, which we've now seen in practice, those issues are all interrelated. And that's why it was our National Assembly that undertook that long and difficult, very hostile process of trying to establish exactly whether or not former public protector Busisiwe Mkhwebane should be impeached. And because of their understanding, so the National Assembly's understanding of the significance of the EFF2 case, where the National Assembly has to try to regulate its affairs in the interests of the country as a whole, and not only in the interests of a certain majority party or particular individuals. That is why the National Assembly has been so careful and thorough in the impeachment process of the public protector, so that it can withstand any scrutiny by the court. Likewise, in future, if a president does need to be impeached, the mechanism will be there to enable the National Assembly to do what is in the interests of the state. So you see how all of these cases, these new cases, have really confirmed the concepts of the rule of law, democracy, constitutionalism, independence of the judiciary, independence of institutions established to advance our constitutional cause, independence of institutions that are central to the administration of justice. That's why the Nkosana corruption watch case is discussed there. Because if you're familiar with those cases, then the theories and the concepts that are discussed in those cases will have meaning for you, and you'll be able to identify them and be able to explain them and explain how they work with reference to as many relevant cases as necessary. Yeah, so I think that really is the best approach I can advise you on in your preparations for this exam. Is you don't have to try to study the minute detail of everything, because you know that you do have access to the Constitution, the textbook, tutorial letter 102. You, I think, should ensure that you have an excellent grasp of those overriding concepts, theories, philosophies that are indispensable to the way in which our constitutional system is intended to function. So transformative constitutionalism is a theory that we in South Africa are pinning our hopes on. And that's why the AfriForum case, to my mind, is so significant, because it shows the commitment of our municipalities and our judiciary in confirming that we cannot simply live in a world that continues to feel alien to the majority of the population. In other words, the Black South Africans who do not feel reflected in the name Ben Schoeman Highway or Johan Rissik Street. Those street names have no significance for the average South African, even the average white, younger South African. So it's necessary then to adopt a transformative approach and to change street names, even cost a lot of money, but to do so because it is consistent with the need to embrace our plural society and reflect those heroes who were prepared to die to ensure democracy. So that's why we have Robert Sobukwe Street, Steve Biko Street, Nelson Mandela Boulevard. So I want you to be feeling, feeling those cases, really feeling empowered by those cases. And I said this, I think, in our very first lecture, that it was in the AfriForum case in particular, and there have been others, where the Constitutional Court justices have been prepared to speak in a local, in other words, indigenous language, in a judgment, because they want to be speaking to the people. They don't want their judgments to simply be these abstract documents that no one really reads or understands. They really want us to live according to these decisions. And these are interesting cases to read. They are written in a poetic way sometimes. I mean, I can't stop coming back to paragraph 31 of the EFF1 case, where Chief Justice Mogoeng said, the president is a constitutional being. He lives, he breathes, he exists in the Constitution. Those kinds of expressions are supposed to resonate with you. And you realize that this Constitution is not just a document that we must have some vague idea about, but we need to live this Constitution. And if we all live the Constitution, my argument is that that is consistent with Ubuntu, because then we are all working as a community united for a common purpose, instead of that Eurocentric approach of everyone working in their little silos, individualized, not worrying about other people. But the African concept of us working together in the context of a scarcity of resources. So even in the context of a scarcity of the National Assembly being prepared to hold the president accountable, there was that scarcity of accountability. And that's why the economic freedom fighters, even if it's not explicitly mentioned in the case law, you can see it's implied that the EFF were desperate for accountability to prevail for the interests of the common society, the common good. So all of these new cases, I mean, I'm not saying the old cases aren't relevant too. There are a number of fundamental cases that you will always need to rely on, like the first certification case. That case is relevant to virtually every aspect of constitutional law. It just depends on how well you can substantiate its specific relevance. But it's these newer cases where our constitutional court has been a lot more in conversation with the people and have been quite a lot more courageous in their decisions, where they might in the past have said, you know, it's not our role to be involved in any manner in how the National Assembly chooses to do its work. But it became so apparent that our entire constitutional democracy was being undermined and eroded by the National Assembly not holding the president accountable, and where 9 successive motions of no confidence all failed, making a mockery of the constitutional provision, saying that a president can be removed from office by force if they're not actually respecting the Constitution themselves, and the political parties have lost faith in him or her. And so that takes us to the concept of the counter-majoritarian dilemma. You must, for example, be able to explain what it means, why we believe it's a dilemma, and why we know that it's not a dilemma. And all of these new cases are excellent authority to explain well that what the courts are doing is not usurping the role of the legislature or the executive. all they are actually doing is reinforcing the fundamental rules in the Constitution, such as the rule of law, the fact that we have an open, accountable, responsive, democratic system, the fact that our Constitution is clear on the fact that the role of the National Assembly is not to be partisan or to cling too closely to the majority party in Parliament, but to make its decisions in the best interests of the majority of the country. And so that's why our courts are able to actually make these far-reaching declarations that certain conduct by the executive is unconstitutional, undemocratic. And that's why the National Assembly, for example, if they are now of the view that the public protector is no longer fit to hold the office of the public protector because on numerous different occasions, courts have found that she has misdirected herself, misconstrued the law, made fatal errors of law, then the National Assembly is empowered as the majority to remove that public protector by way of impeachment. But remember that checks and balances, as another fundamental concept, arises because even when the National Assembly produces a report saying, we have come to the conclusion that the public protector, Busisiwe Mkhwebane, must be impeached, that isn't the end of the road, because then the National Assembly needs to recognize that because the president, as head of the executive, appointed or appoints generally a public protector, it's the same president who must formally remove that person. So that thinking is similar to your knowledge from administrative law in the Masetla case, where if the Constitution says that it is the president that appoints the National Commissioner of the State Security Agency, then likewise it is the president that is empowered to dismiss that person. So that's why we know that we have checks and balances. And so the counter-majoritarian dilemma is relevant, particularly in the context of a discussion of the minority being the judiciary that is given what is assumed to be too much power. But really, it is simply as a counterbalance to the immense power that the National Assembly has. And so you need this method of balancing the two powers so that one isn't so dominant that it, for a want of a better expression, cannibalizes all of the other institutions. And that's why we have to keep coming back and confirming that it is often these smaller opposition political parties that are forced to go to court, like the UDM asking for a secret ballot, the EFF, obviously, the DA repeatedly trying to seek some measure of proper functioning of the National Assembly. So even those smaller political parties, they are not going to court in order to try to govern. They are simply going to court to restore constitutional democracy. So to my mind, the counter-majoritarian dilemma does, in fact, this is what politicians love to say, is they like to say, oh, these other political parties are only going to court because they're trying to govern through the courts. That's not actually the case. It's a situation where going to court is the last possible option. And very often it is these smaller political parties that realize that there is no alternative. They've tried their best to quote the EFF, to disrupt Parliament, disrupt the State of the Nation address in order to bring to our attention that there is a problem that needs to be resolved. But that problem was not going to be resolved by the National Assembly itself. In fact, it had proven that it was committed to doing everything it possibly could to protect Jacob Zuma. Hence, they had to go to court, not because they want to just waste their money and waste their time, but because they were so dedicated to the cause of democracy. And it's not just any democracy, remember. In South Africa, it is constitutional democracy. That is the overarching feature. And within the understanding of constitutional democracy are all the other forms of democracy that work at the same time. Because we have a multi-party democracy, meaning that there are various members of different political parties in the National Assembly. Those persons are there representing us because we have a representative democracy. We have, on a daily basis, as I've routinely said, direct democracy in action when the people take to the streets and protest, speaking to the leadership of the municipality or the province, or if it's a national protest march, where it's trying to get the attention of the leaders and say to them, you need to come and talk to us as worthy individuals with human dignity. You must listen to us and you must try to implement what it is we're asking of you, because what we're asking of you is nothing more than what the Constitution says we're entitled to. So are you with me that it's the concepts underpinning constitutional law that you need to know very well so that you can then explain it and apply it? Application is important. Many students, for some reason, they believe that simply writing a case name is good enough. That's not, because you've not applied the case to the theory to explain its relevance and explain how we as the reader should understand what that concept actually means in theory and in practice. Many people use this kind of an expression. They say, when you're writing an exam, you must sort of imagine you're trying to explain these difficult concepts to someone like, let's, for argument's sake, say your grandmother, who is in a very rural area. She might not ever have had much education. And you must try and explain it so that it means something to her, especially when it's constitutional law, like the right to vote and the processes involved in the election process, that we have an independent electoral commission which has the function to ensure that eligible people are registered to vote, and that therefore your grandmother must be told, don't just sit here at home on that date, go to the polling station, make sure your name is on the list, make sure you have an ID document. And that's one thing I didn't discuss at all, but it is dealt with in the notes, and it's probably a case you know of already. But when South Africa became a democracy, so many Black South Africans who had been systematically deprived of any constitutional rights and had been deprived of citizenship, they did not have the green barcoded identity document that enabled them to vote. And of course, this worked to the advantage of the white minority. But even some of the white people didn't have the right identity documents. And that's why there was a case called the New National Party case, where the court was being asked to delay the elections to enable more people to get the green barcoded identity document. And the court came to the conclusion that on the information it had, an overwhelming majority of people did have the green barcoded identity documents. And therefore, if certain people didn't have it at that first election, it was pretty much just too bad. They had to make sure that by the next election, they had obtained the correct documentation in order to vote. So all of this is important, especially if you have maybe a 17-year-old brother or sister who you say to them, you need to go and get an ID document so that you can sit for your final exams, so that you can get a learner's license, and so that you can vote in the elections. They might say to you, but why must I vote in the elections? What's in it for me? And you need to be able to explain that you are a valuable citizen who's a member of the society. You need to participate in order to have the government that you want, and to be able to put pressure on your ward councillor to make sure that the municipality provides the electricity and the water that it promises. But if you are not prepared to vote, you really don't have much room to complain thereafter. So I'm saying this because I still want you in a law exam to write in a well articulated, academically sound, proper manner, but also make sure that you're actually explaining yourself well enough. Because really, students who just say, in the case of State versus Makwanyane, and then full stop, that means nothing. You have to explain the relevance of the case to the concept you're describing. So that's what I mean by application. Showing that you really can draw those links, those logical links between the concept and how it's been interpreted in a particular case, and therefore what the outcome of the case may have been based on that principle that's now been developed and is a precedent that can be used in future similar cases. So are you feeling a little bit less stressed then? I know you probably don't want to say yes. And I have switched all of your microphones off. But I really, and I will put this in writing on an announcement, the same sort of scope I've just given. But really, if you understand concepts and principles and doctrines, then you understand constitutional law, because it is all premised on these important theories and philosophies and concepts and doctrines that you then need to be able to elaborate on and show which cases really prove that theory. Okay, so Tracy wants to know if you can handwrite. Yes, there's nothing wrong with writing your exam by hand and using in-text referencing. So after saying the counter-majoritarian dilemma is a feature of constitutional law all over the world, something like that, you can put in brackets after that sentence, say, Section 1 of the Constitution, as read with Section 2 and Section 172 of the Constitution, state that the judiciary has power to declare law or conduct invalid. End, close your bracket. And then you might say, the counter-majoritarian dilemma is in a more decolonized form in South Africa. And then your reference might be something like where you put in the case of AfriForum versus the Tshwane municipality, and you say, in the case of AfriForum versus Tshwane municipality, the courts are embracing a more Africanized approach to how the country is to function. Therefore, our courts are not simply trying to override the executive and the legislature in the form of a pure power struggle, but they are trying to transform the country. So I know that those references that I'm giving are actually giving too much detail, but I want you to then be able to say, see page 108 of tutorial letter 102, or see page 74 of South African Constitutional Law in Context, second edition, 2020, Oxford University Press, so that whoever reads your exam, if you haven't told them which edition of the book you're referring to, they might open their second edition and you've actually referred to the first edition. And if you then have the wrong information, that marker might say you are trying to be academically dishonest because you're giving a false reference. And it is false if you haven't given enough information so that the reader knows which source you're actually referring to. Now, I know that I am putting a lot of pressure on you by saying you must use footnotes. But in law, footnotes, or as I'm trying to say, in text referencing, is necessary because your interpretation of something might be slightly different to someone else's interpretation, but is equally valid and correct. And therefore, the person who reads your work might think, I never thought of it this way. Let me go and read that exact information that this student is referring to and see if I then come to the same opinion. So that's why I'm trying to say to you, get used to using references. And in any event, because it's an open book exam and you're told explicitly, do not copy and paste, you've got that additional time to try and use your own words or put particular words into inverted commas, showing that they're not your own words and showing where you got it from. To protect yourself and to make your work more compelling. Because that is what we expect of a law student, is that you can actually explain yourself with appropriate authority. So if you've got a reference that says a certain case, if it's the completely wrong case, then we will be able to say, okay, no, this student really doesn't know what they're talking about. But if it's a good case, then you'll get your marks. And so either you discuss the case in the text, which is probably better, but at least in the footnote, you must say paragraph 82, for example, of the judgment, because you've got that material with you in the exam. And you do have the time, because we don't want your answers to be pages and pages and pages of utter nonsense that's just thrown in onto the page because you copied and pasted 18 pages out of tutorial letter 102. That's not an answer. We need to see your ability to identify what's being asked, answer the question, and be able to substantiate why you say so. And the substantiation in law is always provisions of the Constitution or the law and case law. And so you don't be surprised that every single question of the 6 in the exam will say, discuss with reference to relevant case law. So it's not as though I'm not going to tell you beforehand, you need to know cases. And you can then use those cases to fully persuade whoever's reading your work that you really do understand we call it the nuances in understanding, where you might have a slightly different take on it, but it's still absolutely true and correct. But you must show us that you've got that sophisticated understanding or a solid understanding. You really do understand the concept of separation of powers, of principle of subsidiarity, counter-majoritarian dilemma, all of those theories that are resonating throughout constitutional law. Okay, so yes, you can handwrite. It just might be a little bit more tedious. And also when you do handwrite especially, please just make sure that the copy that you upload is legible, because often the handwritten ones are difficult to mark and they show up as corrupt. Then you get a 0, then it's a long drawn out process to get your results. So remember, as I keep on saying, you get 15 minutes before the exam starts to open the question paper, try and read the instructions. And I do try and keep the instructions short because I know that you're already stressed. But the questions are also short. I haven't gone into long detail in the questions. So just, breathe, read the questions. You've got then that 15 minutes originally, then you've got the full 4 hours, and then you're supposed to start uploading within that next half an hour. And you also need to, within 10 minutes after the close, so 10 past 12, upload a copy on the Invigilator app. So you can't really spend that extra half an hour still trying to fit in answers, but 4 hours is actually more than enough if you know where to find the information and you can explain it clearly without waffling on. All right. So I'm going to upload this lecture and a written little statement on the scope. And I'm referring you again to tutorial, the feedback to assignment 2, where I've used footnotes there. Try and use something that looks like that so that your work is academically acceptable. Okay, so I'm taking it that we don't need any more lectures at the moment. But look, if on Monday, for example, there are issues that you'd like to discuss, we can probably have a meeting. If there are enough of you who want to discuss things, we can have a meeting. Or if you just personally want to discuss something, you can phone me. My computer does have my phone connected to it. So you can phone through Teams, or you send an email and I will explain. So we can have a lecture maybe on Monday or even Tuesday if you really want. But I think there's not much more I can say. It's more about you just looking at the material, getting acquainted with it, reading those cases at the in part 6 of tutorial letter 102 so that you're familiar with them. Highlight, for example, or take notes of what's interesting that you think the judge said, that you think really explains a concept well, so that you are prepared for the exam. Because you don't have that pressure that students in the past had, where you had to study everything off by heart. You do have a benefit now by knowing that you can prepare and still be able to rely on those same sources throughout the 4 hours. So thank you. I'm going to stop the recording now and upload a short little scope. I think it's hilarious that students all want a scope when I can't really give one other than saying it, you have to know everything. But I am trying to give you the scope. Okay, so thank you very much.
Hello.
Yes, don't feel afraid if you need to ask for advice. Yes?
Where will you upload the scope?
I'm going to
here
upload
on the
it.
comments?
Yes, I can do it on the comments here. Also, an announcement on the module sites.
Okay.
It's very
thank you.
short, but yes, let me put it here. In fact, yes. Okay, so thank you very much, and yeah, good luck. But I did not make it a difficult exam. No, thank you for paying attention for these lectures. So thank you very much, and I will speak to you all soon. Thank you. Bye-bye.
Thank you, Prof. Thank you.
Bye. Bye.
Thank you, Prof.
Thank you.